Thank you for joining us for 3Bs on the Law podcast, hosted by Trisha Barita, Camille Canali, and Susan Dawson. Disclaimer, this podcast is for entertainment and informational purposes only, not meant to provide legal advice, and does not create an attorney-client relationship. Also remember, laws change or they differ by jurisdiction, so this is not a substitute for seeking legal counsel in your jurisdiction on the current law applicable to you.
Hello, everyone, and welcome back to 3Bs on the Law. Today, we are going to have a fun conversation about exempt versus non-exempt employees and what does that mean. You know, determining whether an employee is exempt or non-exempt makes a big difference when it comes to overtime, essentially. I mean, there's some other reasons there as well, but overtime is a big one, whether or not you have to pay them overtime, because it essentially means, is the employee exempt from the overtime rules? So the federal salary threshold is the first place that you start, right? So, you know, if you have hourly employees, they're generally non-exempt. There is an exception to that, but generally we're talking about salaried employees for an exempt, if to claim them as exempt. And so we're looking at a salary threshold of $35,568 a year, which amounts to $684 a week. That's the federal threshold, and many states follow it. Illinois follows it. Wisconsin follows it. How about you, Trisha? What about Texas?
Yep, Texas will match that.
But then we have this fun state called California. Camille, how about you?
So California has a very strict test compared to the federal statutes. And so the salary, if you have more than 25 employees in California for 2021 only, is $58,240. And if you have less than 25 employees, the minimum salary threshold is $54,080. But we also have a second prong to that test, and the employee has to spend more than 50% of their time doing exempt activities, which I don't think the states that comply with the federal law have that.
No. Well, I mean, they have, I mean, it's kind of complicated. I've been in these investigations with the Department of Labor and had these discussions with them, and they don't give you a percentage on those definition exemptions, but they do expect, I mean, it basically, I mean, it could be, you know, it could be like 90% of what they expect the person to be doing to be exempt under these definitions. So, you know, there's no reason to play around with it. The person better very heavily qualify under those definitions if you're getting investigated at the federal level of the Department of Labor, in my experience with that. I don't know if you've had any different experiences, Susan.
I agree that you can't, you know, if the one executive or the one item that puts them into an exempt category, they do like once a month, that's not going to fly, right? But we don't have a set 50% threshold or anything like that.
Right. And here's the thing, if you mess this up, the penalties are very high and very costly. And so you really want to make sure when you're classifying your employees that you have them properly classified. And we're not even going to talk about the penalties today, but there is definitely a reason you want to make sure your employees are properly classified.
I would like to add one thing on that I think is interesting in these investigations, which is usually really shocking for my employers that have never been in an investigation. We end up in a DOL investigation. Usually I'm hired right on the spot when that happens. So it's the beginning of my relationship with the employer. So I may, along with them, trying to decide what they're being investigated about. And one of the shocking things the employer struggles with about these investigations is that when the investigator at the federal level is making a determination at whether the classification was done appropriately, the employer is usually not in the room. It's a conversation between them and the employee and their interviews of multiple employees, usually at that level, to determine if they're meeting those standards. And so while you may make a beautiful job description with all the exempt things that you think that they're doing, it will come down to whether or not that employee, it's good if the employee knows whether they're exempt. That would be a first place start. But a lot of times they don't, and the DOL investigators don't, I think, expect that. But what they do expect is for them to be able to say they do these things. And Camille's right, or I remember Susan was saying, you know, if they do it once a month, are they going to remember that they do that? So you really have to understand that they it can't just be pretty on paper when it comes down to being investigated. These investigators are very savvy, and they will get to the bottom of whether or not the person is properly classified. So it's not as much about making a paperwork trail as making sure it actually is a job that's truly exempt to avoid all those penalties Camille's talking about. But I just want to throw that out there for people to think about.
Yeah, this is where you want to make sure that your employees' actions at work actually match the job description, and even a job title. You can call someone a manager and they may not be exempt because they don't meet either the salary or they don't actually perform and have that discretionary and independent judgment requirement that I think we're going to talk about in a few minutes. That's
let's get into that. We've talked about classification, and I think by that we mean exempt or non-exempt in that classification. But under that, there are the exempt categories that a lot of times people don't understand. For example, the administrative one, I think that's confusing because people think, well, that means my secretary. No, she might be your admin, but that does not mean that they fall under the administrative exemption. So Tricia, do you want to kind of take us through a little bit some of these exempt categories?
Sure, I'll do it at the federal level, and then I know Camille's got her 2 cents and all the issues of California. But I think that's great that you bring that one up, Susan, because I think the one that I see the most misclassified, and I think from talking to investigators, that's their experience as well, is the administrative exemption. I think everyone goes, oh, this is an administrative assistant, this is administrative whoever. They meet the salary threshold, done. They're administratively exempt. And that's such a major mistake. And it is so expensive if you get this wrong, because you usually haven't been paying a lot of attention to what these people are doing. You're dialing it in that they're working 40 hours a week or 45 hours here and there. And you don't really pay attention to these few hours they're working because you think they're exempt, but really they're probably not exempt. And the main reason is the definition, the piece of that where that employee that meets the administrative exemption also has to be an employee with the primary duty of exercising discretion and independent judgment with respects to matters of significance. And the Fair Labor Standards Act, if you get into those definitions, is pretty specific about that. We are not just talking about, oh, this person is in charge of the petty and cash. Okay. Like this is matters of significance to the business. So like for all three of us in the world of running a law firm, there are very significant matters of significance that like making decisions about insurance, making decisions about how the IOLTA trusts are going to be run for our clients, making decisions about banking things, salaries. Those are all matters of significance, how clients are going to be charged. All those types of things are high level decisions that are made by the owners, of a law firm or the partners of a law firm. Those would be matters of significance. And having to really understand whether or not you've given an administrative assistant that power is important. I mean, when I ask a client, do they make decisions about matters of significance? Do you give them the exercise of discretion, independent judgment? And the client goes, well, yeah, I totally do. I mean, I have them run everything by me, but, and you're like, wait a minute, they have to run everything by you? And they're like, oh yeah, they have to run everything by me. Well, okay, if they've got to run everything by you, then they don't have the ability, the primary duty of exercising that discretion, independent judgment. And that's a big piece because administrative assistants or people that are lower level administration that aren't in a managerial decision making power, really, usually they don't have that power, right?
Right. And so the great example, using Tricia's example of the administrative assistant, but if you have an office manager between yourself and say the assistants overseeing all of the assistants in the office, let's say you have 15, you're fortunate, your business is growing, it's big, you have 15 or 20 assistants in your office. And so you've hired someone to oversee that and oversee the health insurance and oversee all of the benefits. And they don't have to run, for example, hiring and firing decisions necessarily by you, then that person probably is exempt.
Yeah. So in the federal level, I would argue that person falls under the executive exemption because they're managing more than 2 people. So two or more people, and they're if they're participating in the hiring and firing. But those people, that's certainly like once you start managing people, and they start, even if they don't fully have the ability to hire and fire, Susan and I have talked about this before. If they have the ability to, exercise an opinion, basically a big weigh-in. If they're reporting or they're doing, especially if they're doing the annual evaluation, I think that's making those decisions, or they're doing the disciplinary stuff, that's participating in the decisions that lead up to the termination or lead up to the raises or changes of the employee's ability to work. I think that those people have those decision-making abilities, even if they aren't the direct final decision on the hire or fire. But it's all arguable. And so you want to be real careful about understanding that. And they certainly didn't need to know they have that power, because if the DOL investigator goes, do you have the ability to hire and fire people? Do you have the ability to affect that change? And they're like, I never make that decision. Trisha Burrito makes all those decisions or something like that. That would be that kind of lose out on that. So they need to know they have that power, which means you need to let them have that power, which is it's kind of a hard thing to do, honestly.
Yeah. Well, and that's where the job description comes in, is if you give them the power in the job description and they're familiar with it, while the job description doesn't necessarily control their duties, my hope is that they've been given that job description when they were hired, and they understand that that's the expectation, that they will exercise that discretion and judgment with respect to other employee matters if they're going to be an exempt employee.
And they've seen that job description in the last 5 years. That would be good. Yeah, if they signed it when they got hired and they haven't seen that job description, it's not going to help you a lot in the DOL investigation.
It's also a good idea when you do their annual review, which hopefully everybody is doing. We've talked about those before. That you review their job duties and see whether or not you want to expand or contract any of those duties based upon what's actually happening at the company. So it's a great opportunity to review that with your employee on an annual basis.
I mean, I put right up there in the job description, they're exempt, they're not exempt. And then right up, I think if the investigator is coming and I'm calling them exempt, I like to see in the first 5 bullet points all my exempt reasons on why they're exempt. And then all the other stuff later. But we love job descriptions because they play such a big role. There's, challenges again within these type of investigations, but with your Americans with Disabilities Act, all those things that you want up there. So they are important, and letting those employees see them as Camille says, that's a really good point.
Right. And so, I think we also should talk about things that can affect. So for example, let's say you hired a manager, but during COVID, you had to lay off a bunch of people. And so now that manager is now performing also other office tasks, primarily because you just don't have the people to manage due to layoffs. If you have restructured and that employee's status has changed, they may very well go to an hourly rate and be non-exempt, and you now owe them overtime.
Yeah, that's a little tricky. There were some exceptions and stuff made during COVID. So I think honestly, that's a very tricky question. And I think in the federal sense, I know California may have been a little bit more overt about guiding employers in that realm, because there were some things that came out that said during COVID, if they do end up performing more non-exempt tasks, even though they have an exempt position. Now, I mean, if you start changing their salary and stuff, and you move them right into an hourly, you're gonna you may run into problems with that issue. But I think that's a little more complicated if you're looking at like being in a pandemic and kind of how the government, whether they're going to start taxing you on those issues. But I think one thing is interesting people try to figure out is, can I move these people that are exempt in and out of exempt? Can I just do that? And I would caution people to not do that. It's also a strange thing too. If you have 2 sets of workers, okay, and they're pretty much doing the same thing, and you're declaring one set exempt and the other not exempt, that's a big red flag to those investigators, because they're going to want to really understand why these people are non-exempt hourly workers and the other ones are exempt. And it's not going to make any difference to them that you're like, well, these people want to be salary, but these people don't want to be salary. Like, that's not a moving thing for the investigator. They're like, you're the employer, you decide if they're exempt. Now, they're never going to get mad at you if you keep someone that could be exempt as non-exempt, right? Because then you're going to be paying them overtime. So you're really not going to get in trouble there. The problem you have is that, are you watering down your argument for the other people to be exempt by doing that. And so I kind of think you got to look at all those classes of worker together and go, we're calling it, this group is all that, right? I don't know if you guys agree with me, but that's my thought on that.
I do.
Yeah, the example I often give is, for example, if you have a restaurant manager and business has declined and that manager returns to waiting tables 75% of the time, technically, I think that person would be transferred from exempt to non-exempt under that specific circumstance. And then if business picks up and she goes back to being a manager, that often, obviously you can return her to non-exempt status. The other issue that I see often is people do pay cuts across the company line in lieu of layoffs. And so let's say a company wants to have everybody take a 10% payoff. Well, you have to be really careful if you have an exempt employee that then falls below that minimum threshold because you gave them a pay cut, and irrespective of whether their job duties changed, if they're below that threshold, they automatically become non-exempt.
So there is some discretion in that, I think, on the federal level. I know, Camille, and you might see in California it's a little different. If at the end of the year you meet it, if you get to that level, if you meet the threshold by the end of the year, because you can count in some bonuses and stuff on there. So it's not something to play around with. It's not something I find that it shouldn't be goals to like go in and out of the threshold salary amount. But I think if for whatever reason you did have a cut, but you were able to bring them back up and get that number there by the end of the year, if whatever your fiscal year is, under the federal level, there is some wiggle room with that they give some allowances to that because they do allow for some bonuses to count towards it. So I think you just have to be real careful about that and get guided by some legal advice, because it's, again, if you screw it up, the whole year could be an issue of overtime. So it's not to be taken lightly. It's not like, oh, Trisha said I could fix it at the end of the year. That's not what I'm saying. What I'm saying is, what I'm saying is not, and I'm not saying in California either. I'm saying some states like Texas, we're just very closely aligned to basically following the federal rules. So so I'm very, very familiar with Fair Labor Standards Act and what that looks like. And that's, kind of what we look at. And so I am familiar with that. That is a tactic that can happen, but it's not something that it would be something dire that you were doing it. I think you'd have to really have a plan on how you were going to get them paid by that end of that year. You shouldn't make that decision lightly, because otherwise, are you tracking everybody? And you almost want to be tracking everybody anyway, if that's the situation, just in case you realize you can't make it, so that you could make up everything, all the money that you may owe in overtime or.
Right. That's what I see a lot more frequently is we've classified someone correctly. They're non-exempt. We know they're not exempt. But we're not tracking when they get to work, when they leave work, when they're on lunch. Or when they're on lunch, you run past the lunchroom and you're like, hey, Patty, when you're done, can you don't forget to send that email out. Well, guess what? You now made their lunch, you interrupted their lunch break, and were they now on the clock for that? And have you, right? So that's a much longer discussion, right?
Oh yeah. No, we weren't going to talk about wage and hour issues that you.
Yeah, right. No, that's a much longer discussion. But you were, just to go into that the first thing is figuring out if they're not exempt or non-exempt. Then when you figure out they're non-exempt, making sure you're tracking their overtime or their hours appropriately, right?
Right. Yeah. And if you've misclassified someone as exempt who really is non-exempt, you may have to pay them back pay for missed lunches, missed breaks, and overtime, as well as penalties for that in California.
Big time penalties here in Illinois. Mm-hmm.
It is, a small.
Wait, you guys have to give people. You have to give people lunches out there in California. Is that what you're saying?
We do allow people to eat.
Is that a thing? You get to eat lunch?
We get to.
There's no lunch. Where's that? What's that place I want to go to again? Where like the gas station, the crazy place in Texas. The awesome.
You want to come down to Texas? We don't got a lot of rules about anything. You're lucky if you get. You're lucky if you get lunch down here.
Is it Buc-ee's? What's it called? Right?
She wants to go to
That's-
Buc-ee's.
We're all coming down to Texas to go on a lunch break at Buc-ee's.
No, honey, that's a gas
You know, I
station.
don't know about you ladies, but if it's something that's on the fence, I always err on the side of classifying as non-exempt. It's the safer way to go if you have any questions. You know, you're not going to get in trouble for classifying someone as non-exempt. You can get in trouble if you misclassify someone as exempt.
Okay, and I think it's just before we like close this out, let me just mention these other ones that so I'm not going to go into all the categories, but the main ones that we already mentioned is your executive exemption, your administrative exemption, your professional exemptions. That would be like the three of us. We never get overtime in life. That's what the Department of Labor decided. Computer employee exemption, and then you'll see these highly compensated employees, which is a whole nother thing that goes into they're paid much more than the threshold that Susan was talking about. But another big one is the outside sales exemption. And this is not every person that does sales. So be a little careful about that. That is the closest I've heard where you hear more about the percentages of those people and what they're doing. And they truly need to be outside sales. If they've got an office and they're hanging out at the workplace, working, and then every once in a while they go visit clients, or they go visit clients a couple of times a week or whatever, that's not outside sales to the Department of Labor. So you shouldn't just qualify those people as exempt under the outside sales exemption. You need to look at that a lot more carefully because there's inside sales and outside sales according to the Department of Labor. So I just want to add that in there. Is there anything else, Camille, you want to add that California does special?
We've covered kind of the big bullet points. There is so much minutia. We could have this conversation for days.
I'm sure.
We'll do that offline because I have a feeling the people listening to the podcast are like, yeah, no, thanks. I'm out.
Yeah.
So
No.
With that, thanks everyone for listening to this fun conversation about exempt and non-exempt employees, and join us again on 3Bs on the Law.
Thank you for joining us on today's podcast of 3Bs on the Law. Don't forget to like and subscribe to our podcast. We also welcome any comments. If you'd like to get in touch with us or suggest a future topic, you can email us at 3BsOnTheLaw@gmail.com. And because we're lawyers, we need to remind you that this podcast is not meant to provide you with legal advice and does not create an attorney-client relationship. Thank you again for joining us, and have a great day.